नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां हम आपके लिए एक बार फिर से लेकर आए हैं एक नया लेसन।
No, ma'am.
No, it is not required. Why it is not required? Because this work has not been done in his official capacity. However, when we say that the person is doing any work in his official capacity, then when a private individual needs to file a suit, then in that case he has to file a suit with after giving 2 months notice to the government. किस लिए नोटिस का पीरियड आई टोल्ड यू, ताकि गवर्नमेंट को भी टाइम मिल जाए. लेट्स नॉट वेस्ट द टाइम ऑफ गवर्नमेंट. क्विक रिलीफ मिल जाए. व्हाई देयर इज अ नीड टू गो टू द कोर्ट व्हेन मैटर कैन बी सेटल्ड एट द गवर्नमेंट लेवल itself. They are not wasting public money and all that. So these are the rationales why we have this, right? Now, notice जाएगा किसके पास? Now this is given in the succeeding paras, and it says in case of a suit against the central government, except with the matter relates to railways, the secretary of the government. So if it is a suit against the central government, then the notice has to give to the given to the central government. In case of a suit against the central government where it relates to railways, then it has to go to the general manager of the railways. ठीक है? अगर railways का कोई भी issue है, you have any grievance against railways, then the notice has to go to general manager of railways. Then if in the case of a suit against the government of state in Jammu and Kashmir, the chief secretary of the government or any other officer authorized by the government in this behalf. Now, I think all these provisions will change because now the status of Jammu and Kashmir has changed. So, there is a requirement for, I think, amendment in all the acts that we have. Because if you read any act, it starts with this act is applicable to entire India except the state of Jammu and Kashmir. So, I think the status is still not clear. Are we removing it? Are we going ahead with it? And what is the status? So, I think these modalities have still have to be worked on with. Definitely, India is and was a part of Jammu and Kashmir, and now the special status is no longer there. So by default, it should apply, but still, there's no official notification with this regard, as far as I'm aware. If you're aware, please tell me, enlighten me, if anyone knows about it. Because till I checked, there was no such notification that all this provision will be removed from all the acts, or all the acts will automatically start applying. So I did not come across any of this thing. If you have, please tell me, any one of you. No one? Class. Where Act 2020 says including the state of Jammu and Kashmir. Okay. All the Where Acts 2020 ke?
Yes, ma'am.
Yes, ma'am.
Okay. So I do not have probably the Where Act 2020 ka, so I'll check. So is there a notification? Is there a in the Gazette of India, was there a notification that was published regarding this? Please check, class. Okay, Kamleshwar is saying that 31st October 2019. Okay, was there a notification? If there is, class, please check. Let's do it together. So let's check so that we are aware about it. Right, class? Okay. Now, moving forward, in case of a suit against any other state government, the secretary of that government or the collector of the district, right? So, if the matter... Yes, Shobit.
Ma'am, I have a doubt.
Yes, Shobit.
Ma'am, can you please explain the first subsection of this 80 again? I mean, I'm a bit confused.
Regarding what? See, it says that if your grievance is against the central government, notice will go to. All right. It says if your grievance is against the central government, then a notice will go to the secretary of the government. If your grievance is against the railways. Right, railways is also governed by central government, right? So if your grievance is against railways, then the notice will go to general manager of railways. If your grievance is against the state of Jammu and Kashmir, then the notice will go to the chief secretary of the government. And if your grievance is against any other state, then the notice will go to secretary of the state. Or if it is at the collector level, at the district level, then it will go to the collector. Yes, Shobit.
Ma'am, it is written that no suit or against a public officer in respect of any act purporting to be done by such public officer. I mean, this section, subsection 2.
Okay, I have not come on subsection 2 till now.
Ma'am, in subsection
You're talking about notice का one part.
No, I'm notice one part is. Let me show you.
Please share your screen and show me. Shobit, you can share your screen. I think this option is available to students also.
I mean, is it visible?
It is visible, but it is not legible. I cannot read anything. I can see it. Would you tell me the subsection or
This subsection 2. This is subsection 2, right?
I cannot show it. I can see it, but I cannot read anything. It's blur and hazy.
I'll clear it out. Okay. So section 18 notice. So it is written what save as otherwise provided in subsection 2. No suit shall be instituted against the government, including the government.
Subsection 2 will come to. Subsection 2 will do abhi. ठीक है? What this basically means is that the general rule is that notice has to be given, but there are certain exceptional situation where notice के बिना भी आप suit file कर सकते हो, और वो जो special situation है, they are given in subsection 2.
Okay.
Fine. Okay. That's what it means. Yes, right? And what are these special situations? We'll just do abhi.
Okay.
Right?
Okay. Yeah. Right. Thank you, ma'am. Thank you.
Welcome. Okay. Now subsection 2. What does it say? It says a suit to obtain an urgent or immediate relief against the government. Okay, sorry. Before that, I just missed on the first part. That notice can be given to these parties. I'm still on subsection 1. Clause 1. And it says that in case of a public officer delivered to him or left in his office, stating the cause of action. So when you're giving a notice, you need to leave that notice, give the notice to the public servant or leave it in his office. And what is it that you're supposed to write in the notice? Right? ये नहीं कि मैं आपके अगेंस्ट सूट करने वाला हूँ, बचाओ. Save yourself if you can. Not something like that. What are you going to write? You're going to write firstly cause of action. What is the matter in controversy? Why you, for example, there's a contractor. He was given a tender by the government, and tender का जो requirement था उसने सारा fulfill कर दिया. उसने bridge road जो बनाना था बना दिया है. And now there's a time for government to pay. Government has not been paying. It's been like 10 years now. So he has to file a suit to recover his money, right? So these kind of matters will come in this suit. Right. So he has to write the cause of action. He has to write his name. He has to write the description and place of residence of plaintiff. Now, why place and residence of plaintiff? Ki agar government wants to resolve this matter out of court, let's not go to the court. In that case, the government should be able to contact that person. ठीक है, हम आपका grievance redress करते हैं, आइए हमारे पास. But how will we contact you? Name, address, phone number, everything has to be written on the notice. And the relief that he claims. So whatever relief that he's wanting, he has to write that. So when you're giving a notice to the government, you're supposed to write what is your cause of action, what is your name, what is your address, what is the relief that you want. If the government is in a capacity to give the relief there and then, no issues. If there is no controversy, it has been just a delay, then the government can go ahead. However, if there is a controversy, should we give relief or should we not give relief? Then in that case, they can decide, okay, let the matter go to the court. We cannot do anything, right? And the plaint shall contain a statement that such notice has been so delivered or left. So after 2 months, what happens is after 2 months, the government has not taken any action. The government has not contacted this person. He has not tried to establish any contact with the person. Then what can the person do? The person is going to file a plaint. And when he's going to file a plaint, then after that, he has to write in his plaint that since this is a suit against the government, I have already given a notice to the government, 2 months notice, and here is a copy of my notice. So that's what he's supposed to do, ताकि जिस court में वो जा रहा है, that court can come to know that a notice, he has fulfilled the requirement of notice. Fine class. So now let's come, fine class.
Yes, ma'am.
All right. So now let's come to subsection 2. That what are the exceptional situations where even without a notice, some action, so suit can be filed. It says a suit to obtain an urgent or immediate relief against the government, including the government of state in Jammu and Kashmir or any public officer in respect to any act purporting to be done by such public officer in his official capacity, may be instituted with the leave of the court without serving any notice as required under subsection 1 but the court shall not grant relief in the suit, whether interim or otherwise, except after giving the government or the public servant, as the case may be, a reasonable opportunity of showing cause in respect to the relief paid by this prayed for in the suit. So what does this mean? Let's say there is, the plaintiff says that my cause is urgent. There is an immediate need to give me some kind of remedy, either interim remedy or any kind of remedy. I cannot have interim injunction or temporary injunction or any kind of interlocutory order unless there is a suit. So I want some kind of immediate relief. My matter is very urgent and immediate. So I want you to do what? So I want you to give me a. So I want you to. Sorry, just a moment. So I want you to take up my matter. I do not have a time to wait for 2 months and then file a suit, right? So if the court feels yes, the matter is urgent, the court क्या करेगा? Even without the notice, the court will allow the person to file a plaint, right? The court is going to take the matter, right? After that, however, when the court is giving any kind of relief, then even though notice नहीं था, फिर भी कोर्ट की परमिशन ले ली प्लेंटिफ ने ऑन सूट हैज बीन फाइल्ड, लेकिन फिर भी जब कोर्ट रिलीफ देगा, चाहे वो इंटरिम रिलीफ दे, चाहे वो कोई और रिलीफ दे, वो रिलीफ तभी देगा जब वो गवर्नमेंट को सुनेगा. The court is going to call the concerned government department. A notice will be served and they will have to appear in the court, and only after hearing them about the relief that is being asked for, the court will give a decision. Right? So notice can be dispensed with if the case is urgent, but only with the permission of the court. And in that case also, before granting the relief, the court has to hear out the party. Requirement, you can still wait for 2 months, right? You can give a notice. There is no requirement for dispensing this requirement of notice. So the court is going to order that the court is going to return the plaint, and the court will tell the person, you first give a notice to the government for 2 months, then you come to us if they do not resolve the dispute. Fine, class?
Ma'am, I have a question.
That's fine. Yes, Das. Yes, tell me.
Ma'am, you said that if government official is doing as a personal capacity or as official capacity, mechanisms are different. Mechanism of relief are different. So, but practically what happens, like these two things are not that distinguishable. Many times government officials do the task where their mentality or intention is private, but their act is as a government capacity. So
okay, so there I get you. Sorry, go on.
So, well, in that case, who will decide? I mean, what kind of path one should follow? So, practically, because government official always want, it's as an official capacity, because it somehow give a shield to him. But I mean, how should one go? How plaintiff should go in that case?
Alright, Sabine, I got your question, and I think you are referring to, basically, if I can gather it correctly, you're referring to the corruption matters which happen, where you're taking a bribe for yourself and doing an official act, right?
Many times, in general, it's misusing the official capacity with the intention for the personal benefits.
Right. See, that's what we are talking about here is not the corruption cases or you're misusing your official capacity. For that, we have different legislation. We have Prevention of Corruption Act of 1988, which was amended in 2018, right? So we have this Prevention of Corruption Act, which looks at such prosecutions. If there is a government official or any public servant for that matter, he is indulging in any act of corruption, then in that case, this is a criminal offense and the person can be prosecuted for it. Right? So that is a different, I understand your concern that you think all things is intermingled and everything is just the same, but that is not the case. Corruption cases will go under Prevention of Corruption Act or it will go under IPC. ठीक है, यहाँ पे हम जो बात कर रहे हैं वो ये है कि देयर इज अ पर्सन, लेट्स से मेरा गवर्नमेंट के साथ एक कॉन्ट्रैक्ट था कि मुझे रोड बनानी है एंड द गवर्नमेंट वाज सपोज्ड टू पे मी मनी। मैंने अपना कॉन्ट्रैक्ट पूरा कर दिया लेकिन गवर्नमेंट ने अभी तक मेरे पैसे रिलीज नहीं करे हैं। इट इज स्ट्रिक्टली इन द ऑफिशियल कैपेसिटी कि गवर्नमेंट जो ऑफिसर बैठा है, लेट्स से देयर इज अ डिपार्टमेंट ऑफ व्हाट, व्हिच डिपार्टमेंट, द कॉन्ट्रैक्ट वाज गिवन बाय अर्बन डेवलपमेंट मिनिस्ट्री और व्हाटएवर, right? So we are I do not have a one-on-one contract with the person in charge, with the minister in charge or the administrative service personnel who is sitting there. I have a contract with the government. I have a contract with that ministry, right? So in such a case, if I wanted it, I am the plaintiff. This requirement of notice is only in the case where the person, the plaintiff is a private individual, right? So I am a plaintiff, so I have a grievance against the government. I want the relief. So I'll say the CPC is saying instead of going to the court, first give chance to government. If they resolve your dispute, fine. Otherwise, then go to the court. So 2 महीने का जो नोटिस का पीरियड है वो इसलिए है कि वो आपके ग्रीवेंस को रिड्रेस कर दे। The thing that you are talking about will come under, और उसका बिल्कुल ऑपोजिट केस होता है, जैसे कि किसी ने, मैंने आपको जो एग्जांपल दिया था, person is buying a house, person is selling a house, he takes the consideration and he does not give the house. Now he's not, the plaintiff wants a specific performance of the contract. He wants the house to be sold because सारा का सारा पैसा ले लिया, at least 50% of money you have taken and now you're refusing to sell the house, right? So this is a transaction, or this is an act which the person has undertaken in his personal capacity, not as a minister in urban development ministry or not as a official there. This is his personal contract. उसके लिए नोटिस की रिक्वायरमेंट नहीं होगी। अगर कोई उस पब्लिक ऑफिशियल को, उस पब्लिक सर्वेंट को सू करना चाहता है उसकी पर्सनल कैपेसिटी में, तब नोटिस की जरूरत नहीं है। लेकिन अगर आप करते हो ऑफिशियल काम के लिए कि मेरे टेंडर का प्राइस, मैंने आपका कॉन्ट्रैक्ट कर दिया, आपने मुझे प्राइस नहीं दिया, मोस्टली जो केसेस गवर्नमेंट के अगेंस्ट होते हैं वो यही होते हैं। प्राइस नॉट पेड। यस
मैम वो करप्शन वाला मेरे को समझ आ गया, बट मेनी टाइम्स क्या होता है कि पर्सनल ईगो, या आप जानते हैं आपका काम रोकना चाहते हैं, कोई मॉनेटरी बेनिफिट नहीं चाहिए, बट जस्ट टू सेटिस्फाई देयर ओन प्राइवेट इंटरेस्ट, मे बी पर्सनल ईगो मे बी द रीजन. So if you are obstructing
if you're obstructing any work on the ground of ego, if there is no ground for it, then it can cause for a disciplinary action. But it will not lead to a civil suit. See, just understand, Sudhir, that I cannot go to a court and say that this officer does not like me or I had an argument with him and that is why he is not doing my work. There is no way.
So in that case, all acts will be considered as in official capacity only. So even
then you can go to the court. Just hear me out, Sudhir. In that case, you can file a writ of mandamus in the court. Let's say there is a public servant. He is not doing the duty that he is supposed to do. You can go to the court and file a writ and ask him for mandamus. Ask the public servant to do his duty.
Right.
Okay. Now let's come to section. Let's come to clause 3, and it says, no suit instituted against the government or against the public officer in respect to any act purporting to be done by such public servant in his official capacity shall be dismissed merely by the reason of an error or defect in notice referred to in clause 1, if in such notice. So if there was a notice that was given and there was some error in notice, I have told you what all you have to write. So let's say the person did not write all these things that he was supposed to write, right? So this itself will not lead to the dismissal of the suit until and unless, because of this error or defect, what happens? If in such notice the name, description and the residence of the plaintiff has been so given as to enable the just wait, let me read it again. No suit instituted against the government or against the public servant in respect to any act purporting to be done by such public servant in his official capacity shall be dismissed merely by reason of any error or defect in notice. If there is any defect in notice, that will itself not be a ground for dismissing the suit that the plaintiff has filed after giving notice. If such notice has what? If such notice has the name, description and the residence of the plaintiff had been so given as to enable the appropriate authority or the public officer to identify the person serving the notice, and such notice has been delivered or left in it at the office of the appropriate authority specified in subsection 1, and the cause of action and the relief claimed by the plaintiff has been substantially indicated, right? So if there is any defect, error in the notice that is given by the plaintiff to the government before filing a suit, this itself will not be a ground that dismisses suit. The notice was not properly given. If notice में क्या क्या था, notice में the name and the address of the person was there, so that why and cause of action was there, name, address, cause of action and relief was there. So in that case the government can always contact the person. अगर notice official के पास पहुंच गए, notice should be served, notice should reach the office. ऐसा नहीं कि आपका notice पहुंचा ही नहीं है, then it's a different matter altogether. But if the notice has reached the officer, then in that case the name is given, address is given, cause of action is given, relief is given. In that case you can always contact that person and find out, okay, what is your grievance, what was the tender, when what is given, all the other details that you need to find out. Even if they are not mentioned in the notice, the government can always contact the person and find out these details. Fine, class. So this is all about notice. If anyone is having any questions, they can ask.
Yes, ma'am. I have a doubt.
Yeah, sure.
Ma'am, section 80, subsection 1, fourth line. Until the expiration of 2 months next after notice in writing has been delivered. Ma'am, it means that if there is any unlawful act done by the government, then you can only file a suit after before the period of 2 months after the unlawful act is done.
No, Shobit. This basically means if you have any relief that you want to ask from the government. First of all, one thing has to be clarified, that if there is any corrupt practice that is done, if there is any illegal act done by the public officer, right? If it is covering under the criminal act, then it will be taken up by criminal matters. We are only referring to civil matters. Civil matters कौन से होते हैं? किसी के पैसे नहीं दिए हैं, गवर्नमेंट ने Anjali has given an example, DDA flats, government taken advance money but not given possession. ठीक है, गवर्नमेंट पैसे ले लेती है DDA flats के, पर possession नहीं देती है. So you want a quick relief that it's been 10 years that we have paid the money, give us the flat. So ऐसे वाले जो relief होते हैं ना, उसके लिए आपको notice देना होता है गवर्नमेंट को. जो क्रिमिनल एक्ट्स होते हैं या जो अनलॉफुल एक्ट्स होते हैं, उनको तो क्रिमिनल मैटर्स में हो जाते हैं. वी आर हियर ओनली कंसर्न विद द सिविल मैटर्स. फर्स्ट थिंग. सेकंड थिंग इज 2 months notice basically means what? If you have a cause of action, right? आप सूट फाइल करना चाहते हैं, सूट फाइल करने से 2 महीना पहले आपको नोटिस देना होगा गवर्नमेंट को, राइट? यू हैव गिवन 2 months नोटिस, ठीक है? और 2 महीने में अगर आपका इशू रिजॉल्व नहीं होता है, then you can go ahead and file a suit. That's
okay, ma'am. Okay, ma'am.
Fine.
Okay.
All
yes,
right.
ma'am. Yes.
Class, any other doubt? Okay, if no doubt is there, that's all for today. And those who have not given the attendance, please put it in the chat box. I'm quickly putting rest of.
दोस्तों, ब्रास फ्यूजन आशा करता है कि आपको हमारा लेसन पसंद आया होगा. कमेंट बॉक्स में अपना फीडबैक देना ना भूलें. थैंक्स फॉर वॉचिंग.